What is the response time for a residence or visa application as the spouse or partner of a non-European foreigner? And what to do in case of refusal?
From the date indicated on the acknowledgement of receipt of your visa application, or on the Annex 15 bis if you submitted your application in Belgium via the municipality, the Immigration Office has a response time of 9 months, which can be extended by 1 or 2 additional periods of 3 months in case of complications, for a maximum total of 15 months. In case of a positive decision, either you submitted your application in Belgium via the municipality, and the orange card you received after the initial admissibility check is replaced by an A card valid for 1 year, or you submitted a visa application and the embassy or consulate affixes a D visa, long stay, to your passport, which will allow you to come to Belgium. Upon arrival, you simply need to register at your local municipality to be entered in the Foreigners Register. You will then receive a temporary residence document valid for a maximum of 45 days called Annex 15, pending a residence check by a local police officer. You will then receive your A card, valid for 1 year. Whichever procedure you follow to obtain your A card, you will have to request its yearly renewal for 5 years, provided the family reunification conditions remain fulfilled. Only after 5 years will you be granted permanent residence. In case of refusal of residence or visa, you can react in 3 different ways depending on the grounds of the refusal. First scenario, the refusal is based on the fact that you did not validly prove that you meet the family reunification conditions. This is the most frequent case. Over the more than 30 years I have specialized in this field, I have encountered hundreds of refusals due to poorly prepared or incomplete files. In such cases, lodging an appeal is useless because no judge will rule in your favor if you do not meet the legal conditions. Moreover, the administrative judge's review is limited to checking the legality of the Immigration Office's decision. He cannot substitute his own assessment for that of the administration, nor can he grant you the residence or visa himself. At best, after many months of proceedings, an appeal can only result in the annulment of the decision and the return of the file to the Immigration Office for a new decision within another 9 to 15-month period, which means a considerable waste of time. In short, in this scenario, the solution is to submit a new application based on a properly prepared file. However, there are special cases where an incomplete file can be corrected amicably without an appeal being necessary. You simply need to contact the Immigration Office to request a review, which is possible. For example, if you submitted an unregistered rent agreement or a health insurance certificate not compliant with the official template required by the Immigration Office. Second scenario, you submitted a perfectly documented file, but the Immigration Office refused, wrongfully, in your opinion, to grant you the requested residence or visa, committing what you consider a clear illegality. In that case, and only in that case, you must lodge an appeal at the Council for Alien Law Litigation, Conseil du Contentieux des Étrangers, but be aware that in family reunification matters, the Immigration Office rarely violates the law, so an appeal is rarely useful, so beware of those who might encourage you to file an appeal. Lucrative for them, but useless for you. Third scenario, the Immigration Office contests your marriage or legal cohabitation, claiming it is simulated or fraudulent as a sham marriage, and therefore refuses to grant you residence or a visa due to the absence of a valid family link. In this case, an appeal before the Council for Alien Law Litigation is useless because the issue falls under civil law and not administrative law. You will have to act before the family court to obtain validation of your marriage or legal cohabitation. In any case, before lodging an appeal, I strongly advise you to consult a lawyer who is truly specialized, not only in immigration law, but specifically in family reunification matters.